So the first slide here talks about the introduction to legal negotiations. Now, this slide is particularly associated with what in our 4-day program would be a negotiations problem. So that the problem assigned to the students attending this course would have to do with formulating a joint venture between America and citizens of another country. We, of course, do not have opportunity to present that problem today, but it's important to realize that the skills that I'm going to speak about can only be learned fully when put into practice. There's a difference between academic knowledge, which of course is important, and skills which take that academic knowledge and apply it to the problems that we face in everyday life. So this is the setting for the problem that we will not have opportunity to discuss. And similarly, this slide also reflects the nature of a joint venture and thus the specific form of legal issues that would arise in that problem. Again, we will move on to the more general knowledge, and I think very important knowledge, negotiation versus legal negotiation. Again, I appreciate that this is not the students of the Faculty of Law at this university, but rather you are students of international communications. But the principles that I'm about to discuss here are equally applicable. In other words, there are negotiations that are conducted in what we would call the first person, where I negotiate on behalf of myself and you on behalf of yourself with respect to any matter of life, whether there's negotiations with respect to division of labor within the family or marriage, or negotiations in connection with the transfer of intellectual property. We can negotiate directly with another party. However, as students here, and speaking to my students as students of law, we move from what we would call first-person negotiations to third-person negotiations. That is, when I negotiate on behalf of a client, it is not my interests which are paramount and foremost. Rather, it is the interest of my client, whom I represent. And that will be true in any kind of business context. So even if you are not an attorney, many of you will be working for large corporations, and you will be representing that corporation with regard to negotiations with another entity, perhaps even larger than that for which you work. So what is the difference? What are some significant differences between negotiating in the first person on behalf of myself and negotiating in the third person on behalf of someone else? Remember, first place here, of course, your client, your employer's goals, or the state's goals. Are you working for the government? If you're working for your government, those goals, not yours, are what are important. And similarly, because you're negotiating on behalf of someone else, your knowledge of the facts may be less than complete. In other words, you do not know from the first-hand, first-person point of view all of the interests of your client. So you must keep in mind the fact that your knowledge of your client's position may be incomplete, which should give you some sense of humility when entering into such negotiations. Thirdly, the point we have here, which I think is very important, as part of your role as a lawyer or anyone who's negotiating in the third person, to educate your client, to educate the first person about the nature of the transaction. We often, when we negotiate on behalf of ourselves, allow our emotions not only to affect our judgment, but sometimes to overwhelm our judgment. When you're negotiating on behalf of someone else, it is your opportunity, in fact, it is your duty to step between your client's perhaps strong emotional, strong business, strong interest in a particular result, to step between that and the negotiations with the other party, to educate your client, your business owner, your government, about the nature of the transaction and what can reasonably and legitimately be expected to be the result of that transaction. Your role as a negotiator is as much to assist the party for whom you are negotiating directly as it is to achieve the goals of that party in discussions with the other side to those negotiations. Let's then move to the next slide here. How do we do that? Well, the first place, of course, is you must understand your client's goals and clarify your role in the negotiations. Again, there's that gap between your knowledge and your client's knowledge. You want to shrink that gap to as small a position as possible. In other words, you must learn everything you can within time available about your client, about your business, about your government's interests in connection with the matter under negotiation. Organizing your team, often there are more than one person engaged in the negotiation process for a large transaction. That team must be organized and itself must have a system by which the various opportunities for each team member to come to a certain amount of knowledge can be shared with other members of that negotiating team. You must determine the range of possible solutions to the problem under negotiation. Whether the problem is one of intellectual property, or the sale of goods, or a treaty on behalf of a national government, you must understand the range within which you can reasonably expect a solution to come about. Next one here, which I think is extremely important, next point that is, you must learn about the other party. It is not enough that one who is negotiating know one's own position, that is the position of one's own client. You must, to the extent possible, come to a deep-rooted understanding of the other party to the negotiations. And finally, you must, what I summarize in 3 words, or actually one word repeated 3 times, instead of the long expression, formulate proposals and fallback positions in advance, I would summarize all of these points with the